Divorce Talk Radio does not give legal advice, neither does it reflect the views of Rockford College. To obtain legal advice, you need to retain an attorney in your own jurisdiction.
Good evening, folks, and welcome to Divorce Talk Radio. I'm co-host Chris Benson, and tonight we're talking with attorney Brad Tengler.
Good evening, folks. This is Brad Tengler here on the Divorce Talk Radio show.
Tonight we're going to be talking about the divorce process. And Brad, could you tell me a little bit about yourself?
Sure. Prior to being an attorney, I was a high school English and journalism teacher. Now I am obviously a divorce attorney and co-host the show with you, Chris. And absolutely love what I do.
All right, what made you be an attorney? What made you want to be an attorney?
A bunch of reasons, but I love to argue, and it's great to be in court.
All right. And are you originally from the Rockford area?
I am not originally from the Rockford area, but I've been in Illinois for the past 20 years or so.
All right. So tonight we're talking about the divorce process. I'm married and I'm gonna go through a divorce. I made my decision to go through that divorce. I'm gonna hire an attorney. All right. So can you walk me through that process?
Sure. When you say walk you through the process, what do you mean?
So basically, I know I want a divorce. I'm looking for an attorney, and I'm gonna come to you and tell you that I want to go through a divorce. All right. I want to divorce my partner. What do you do from there once I contact you?
Sure. Well, there's a variety of steps that we go through when we're sitting down, and by we I mean divorce attorneys, when we're trying to figure out a case and find out the proper way to proceed. And it begins with obviously sitting down and meeting the client or meeting the potential client.
Okay. All right. And so you met, and then what happens after that?
Well, I'll take a step back because there's a lot about meeting the client.
Right.
For my family cases, I always offer free initial consultations. The reason being is a lot of times people don't know me from Adam unless it's a referral, and it takes time to get to know people. And in the divorce process and taking someone through the divorce process, it's very important that you get to know your client because everything about them can go into your case, especially if there are children involved and there's a potential custody battle that's looming before you.
Now
go ahead.
That free consultation, is that a standard thing, or is that something that's kind of unique to you, or is that
by standard you mean here in town?
Here in town, yes.
It depends. I think a number of people give initial consultations with no charge. It depends on the length. Some people only do it 15 minutes. Some people don't have a set time. I generally don't have a set time, because I think it takes a good bit of time to, number one, figure out the case, to find out the specific facts that you need to figure out, and then figure out whether or not this is a case you want to take on. And obviously the client has to determine whether or not they want to take you on as an attorney, and that means getting to know you a little bit.
Now, you said you might not want to take on a case. Could you explain to me, I don't know if you can tell me, what would make you not take a divorce case?
Well, I generally take most of the cases that come in if, clients, obviously there's a financial obligation and you have to handle the retainer side. But sometimes, you might find out that you represented someone else in the family, or there might be some kind of conflict like that, and so that would be a reason why you might talk to the client and say, hey, I don't think this case is particular to me, especially if I represented someone with that you might feel is a conflict or something like that previously.
So it's conflict of interest, not because of anything that the client might have done?
Oh, of course
not.
Yeah,
Right.
As attorneys, people coming to us, regardless of the situation, we take on cases with, sometimes we have exceptionally well-behaved clients. Sometimes we've got clients with, all kinds of issues. It doesn't matter. Your job is to represent them. Your job is to provide them with, so they understand the law, and then, vigorously represent them.
Right. Now, so I've come in, we met, I've decided that I'm going to retain you.
Okay.
Okay. We've had a conversation. You know what's going on with my marriage and my pending divorce. All right. I've paid you the retainer. What happens next?
Well, something happens before then, too,
Okay.
before I'm paid the retainer.
All right.
And that is, I get to know the client. I get to know, they come in, you figure out, are they getting along with their soon-to-be ex? Do they have children? And you get to know all the facts in the case.
Okay.
Why is that important? It's important because it helps you know what petitions you need to file. So during that initial consultation, I'll take 20 or 30 minutes usually to get to know the client, to get to know their financial circumstances, to get to know their family-related circumstances, to get to know those kinds of particular things which will shape the case. And then I make a determination about what kind of petitions need to be filed. And that usually occurs before the client makes a determination about whether to retain me.
So by the time they decide to retain you, you've already put a decent amount of work into it.
Not work, I would say, but thought.
Thought.
I like to, in my mind, have a roadmap for how I want the case to flesh out. I'll give an example. A mom comes to me, she's 37, has children ages 2, 5, and 9.
Okay.
Husband makes $100,000 a year. She makes $15,000 a year doing odd jobs. So in that particular factual situation, there needs to be a petition filed for temporary relief. And what is temporary relief? Well, it includes temporary child support. If the husband is working a full-time job and she's been a stay-at-home mom, absent other unusual circumstances, she's usually going to get custody. And so you need to file a petition for her to get temporary custody, temporary child support, and in addition, probably maintenance.
And maintenance is?
Maintenance is money that is paid, used to be known as alimony,
Okay.
to the spouse who is not the major earner. So it could be the husband, it could be the wife, it depends on the financial circumstances. And there's a whole bunch of factors that go into how much maintenance should be and how long it should be, but at an initial beginning of the case, when you've got a factual situation such as the one I just described, there's going to be some maintenance that the court's going to order.
Now you mentioned that in your situation there was a stay-at-home mom, correct? Now, would there ever be anything like some education credits or something that, you mentioned maintenance, but would there be anything so that she could improve herself to get a job, or is it just flat-out maintenance?
When you say, what do you mean by education?
Such as maybe attending college or community-based education so that she could get a job since she'll be a single parent. Is there anything like that could happen?
Absolutely. Let's say I'm debating about what kind of petition to file there initially and what kind of petition for temporary relief. And if she needs to get an education so that she can support herself after the divorce,
right.
Absolutely. That a court is going to take that into consideration when determining the maintenance amount and provide a maintenance award that helps her with that. And that's something that when I'm sitting down and planning out the case with my client or my potential client, will go into whether that specific request should be included in a petition for temporary relief.
All right. So can you mention some other type of petitions? So, basically someone who doesn't know about divorce, you think you'd get an attorney, you'd sign some papers, and maybe there'd be a divorce or maybe there'd be a custody battle. But what are these petitions? You mentioned petition for temporary relief or maintenance. Could you elaborate more on some of these other types of petitions?
Other kinds of initial petitions? Sure.
Yes.
Well, there's obviously the basic divorce petition, the petition for dissolution of marriage.
Okay.
And in that petition, you are requesting the court for a divorce, and that's why they're coming to you in the first place.
Right.
So that's the petition that gets the case going.
Okay.
And then a minor petition, a lesser petition, would be the petition for temporary relief. Other petitions might be, let's say the same factual situation, but a few different changes. Mom also wants to move to Beloit, Wisconsin, because her parents are up there.
Okay.
Well, that's Wisconsin, and in Illinois, you have to get leave of court to remove the children, even if you have custody, from the state of Illinois. If you don't, it's a criminal act. So that would be a very important petition that you would want to file with the divorce petition, and plan that out with your client when they're sitting down talking to you for the first time, or at least that's what I do. Okay. So, after talking with them, finding out facts about the family, after figuring out what kind of divorce petition, what kind of petitions need to be filed, and then they retain me.
All right, what's going to happen?
That's the initial process.
So that's the initial process. Nothing's been signed yet. Nothing's been done. Just a consultation. You find out about them.
Right.
And in that, when you're finding out about them and hearing their story, you're deciding what petitions you're going to file. And in your head, you're figuring that into the cost of the retainer. How difficult is this divorce going to be? Yeah. Or is your retainer standard? Is it one time? Okay, this is what it's going to be, or is it a case by case situation based on what you think the divorce is going to be like?
I figure it out on a case by case basis based on the complexity of the facts. But once we get that resolved, we begin the next step of the process.
And that's the court process. You're going to start?
Almost. What I do then is I get people in about 2 weeks later. It gives us time to do the research that we might need to do. If there's some research that needs to be put into the specific types of petitions we need to file, and then sit them down, review the petitions with them, and then file them, and then obviously the next step is we get in court.
Okay. You're deciding to file these petitions, and then we're going to finally get in court, right? How long has this taken from when I initially consulted you? Say we moved ahead right away, we didn't waste any time. Where are we at right now?
That's a really good question, and actually one of the main questions that my clients always ask me is, Brad, how long is this process going to take? Can you give me an exact number? That, and how much is the entire process going to cost? And I always tell them I will not give you an answer to either of those questions, because quite honestly it depends on how much you guys fight. If there is a lot of fighting and arguing over toasters and 5 minutes late on visitation, just a little bit, just a little bit. If you have fighting over the minor issues, it dramatically increases the cost of litigation. And I always talk to my clients about, it's not just the financial cost, it's the emotional cost.
The longer it drags on, the bigger the emotional toll.
Not just the longer it drags on, the more intense the arguing is, it plays a toll on the parties. But
of course.
It usually takes, after we file the petition, if it's not an emergency situation, we get in the court within 2 or 3 weeks, something like that.
So emergency situation, could you elaborate on that? We're talking about maybe a danger to the children or the spouse?
Sure, absolutely. Client comes to me and sits down, and we begin the process of talking. And I find out during the course of that conversation that the night before, let's say my client is our potential client is a young woman, and that her boyfriend, they have a child together with her boyfriend, and her boyfriend threw up her against the wall and threatened her with a knife.
Okay.
Well, we don't mess around with that kind of stuff. That kind of stuff, you need to get in court immediately. And my advice to that client will be, before you give me any money, you go into court tomorrow morning at 8:30 and you file for an order of protection. I am very cautious about filing those petitions, but when they are necessary, they are absolutely necessary.
Right.
You don't waste any time with that kind of stuff. If someone's being threatened with a knife, if someone's head is being shoved into a wall, if children are seeing this, then you need to get into court right away.
And that'll be, this is just a question from somebody who doesn't know about that process. That might be entered into evidence maybe in the divorce. That would be something that would maybe lean on the judge said, hey, there's an order of protection. There definitely needs to be a dissolution of marriage here, and that would maybe affect the divorce custody? And how it goes in custody and everything.
Absolutely. If a divorce begins with an order of protection because there's been some outrageous behavior on the part of one of the parties, that certainly is going to affect the judge's perspective about the rest of the divorce. If the petitioner is deemed by the judge to be credible and honest and not exaggerating, it can backfire if someone goes into court and lies about alleged abuse, and the judge thinks that they're lying, then he's gonna or she is gonna take that into account as well. Often people do not lie about that kind of stuff. I certainly would hope not, and I don't think that's the case. I think
not that often.
Obviously, that's why we have orders of protection to protect people who, in emergency situations, are being abused, and children who are either being abused or witnessing it. But that's not the norm.
That's not a normal thing that happens.
It's not the norm. Normally, it takes 2 weeks, 3 weeks to get into court for those initial petitions that need to be filed.
Okay, so you filed the initial petitions. It's been a couple weeks. What's happening now? Do I need to come in and sign some papers?
During those 2 or 3 weeks between the time that we file the petitions and between the time that we get in the court, there's usually not much happening. I might have if there's a maintenance issue, I might have my client prep by filling out and completing a financial affidavit before we get into court. But normally, all the legwork has been done between the time that they've retained me and the time that we've drafted the petitions. And once those petitions are drafted, I usually have all the information I need for when we're in court in 2 or 3 weeks. And then we appear in court, usually with a petition for temporary relief, and the judge begins to address things.
Great. Now, do you do any research on the other party? Say I come in for a divorce, and are you going to do any research, or is that done in the courtroom when you're talking to the opposing attorney?
It depends. If I know we have a looming custody battle,
right,
I'm going to want to begin prepping the case by getting as much information as I can about, obviously, my client as well as the other side.
And how would you go about doing this research?
Well, for instance, if it's a custody case,
okay,
I want to know if the opposing side has a criminal background. I want to know if my client has a criminal background, because that kind of information is going to come out in court. And if I am going to be giving my client good legal advice, I have to know the good facts and the bad facts. In fact, what I tell my clients all the time is, listen, I need to know everything. I need to know the bad things. I need to know the things that the other side is going to lie about you about, or if they lie about, what will they say? Because the worst thing that can happen to me in court is not that a bad fact exists. The worst thing that can happen to me in court is not to know that a bad fact exists.
So you want to know everything?
Absolutely.
And I didn't ask this before, but how long is this going to take you? How long does it typically take you to ascertain the facts? How long do you spend getting to know this person, finding out about them? When you're asking them questions in the initial consultation, like how long do you feel like you got a good story on your hands?
Well, it takes you form an initial kind of understanding of the case, and then you continue to find out more and discover more as the case develops, more about your client, more about the other side. It's a process. It's a process.
So it's multiple visits, multiple times. You don't find everything out the first time, right?
Absolutely not.
Okay.
It's just like any kind of situation when you're getting to know someone.
Right.
You try to get as much information as possible, but it's a process of getting to know them.
Okay. So, we've met. You've decided what petitions to file. You've with these temporary issues. Okay, where are we going from there now? So you filed the petitions for me, right?
Right.
Okay. We're getting the first couple weeks has gone by, and now we're going to go to court. And do I need to be there?
Normally, clients do not need to be in court.
Okay.
That's one of the benefits of having an attorney is, you can pay us to be there, and you don't have to be there.
Do most of your clients abstain from coming, or do they want to be involved and go to the court dates?
Well, it depends.
Okay.
If clients don't need to be there, I tell them they don't need to be there. But there's two situations. One is a must. One is something that is my preference, that I always want clients there.
Okay.
Usually, the first time we're in court in a divorce case, when I file the petition for temporary relief, I want my client there, even if it's simply set for status. The reason being is I want the judge to meet my client. I want them to put a name to a face. I want to see that my client is vested in what is happening. Now, after that initial court date, there is usually a status or a pretrial, not a hearing date. And at those statuses and pretrials, my clients generally don't need to be there. I always want people to be available by phone in case I need to step outside the courtroom and call them on my cell phone. But generally, they don't have to be there. If it's a hearing date, meaning we have a trial where the judge is going to make findings of fact, then they need to be there. But that doesn't happen early on in the case. That happens at the end of the case. And in some situations, it never happens at all because the parties come to agreements either by the attorneys talking or by the judge making a recommendation and the parties agreeing based on that recommendation. But
Right.
that first time we're in court, I usually have my clients there.
How long does that take? How long will you and the client be in court for at the first time for that initial one?
How long will we be in court?
How long are you standing in front of the judge for?
Oh, 2 minutes.
2 minutes.
Nothing.
And these status,
But
these
we
status
might,
things
we might be waiting for an hour.
for now. Correct. You're waiting for a while, but you're only in front of the judge for a couple minutes.
Exactly.
He's not trying to figure out everything. He just looks at the paperwork,
Exactly.
meets the client, and then are typically both. Now the opposing attorney, will they be there at the same time?
Yes, they need to be
So-
provided.
So everybody will be there.
They need to be provided with notice of your petition. So if you file a petition for temporary relief, you can't try to sneak it in.
Right.
You got to mail it to them. We usually mail and fax it to opposing counsel. Or if the other side does not have an attorney, then we mail it. But yes, they need to be put on notice.
Now you said you'd mail it or fax it to the opposing counsel.
Yes.
How do you know who the other person is having represent them? Who's representing my future ex?
Sometimes I don't know until the day of the court date.
Okay.
And then someone comes up to me and says, "Hey, are you Brad Tengler?" Yes. So I'm representing so-and-so on the other side. I said, "Oh, okay," and then we talk.
Now, is it friendly between you guys? Opposing counsel? Do you typically know the other opposing counsel? Rockford's a small town, so...
Rockford is a big, small town. So, yes, we generally know the opposing counsel. And despite the vehemence in the family courtrooms, and
Right.
There's other attorneys who are not necessarily divorce attorneys. They always make fun of us for how intense it can be in our courtrooms. There is a degree of collegiality that, even though we need to very much vigorously represent our clients in the courtroom, a lot of things can get done, and a lot of drama can be done away with by reasonable discussions.
Okay. So you know the other attorneys, and it makes it easier to talk to them. I mean, so...
Sure.
So, you might have some attorneys that maybe you don't get along with in Rockford. I'm not trying to say that you don't get along with any attorneys, but would that make the divorce a lot more difficult? Say you're representing me, and someone maybe that you had a difficult case against in the past, and kind of soured the relationship between you guys. Would that make the divorce more difficult if the opposing counsel has a problem with you as an attorney?
Well, I don't think that generally
That doesn't happen.
I don't think that's generally the case. I think that some attorneys tend to be more aggressive and litigious, and that can sometimes make what a case that could be simple more expensive and complicated. However, simply because an attorney is aggressive and more litigious, that's not necessarily a bad thing. You need vehement representation at times. At other times, it helps both parties. It helps your client when people are much more reasonable, don't file a lot of petitions, and try to make the process go as smoothly as possible.
Right.
But obviously, there's many times in court that calls for vehement argument, and that's part of our job as divorce attorneys.
Right. Okay, so where are we at now in the divorce process? You've had the status. We're talking about some of the status dates and everything. Where are we at now? What's happening in the divorce? How much time has elapsed?
Well, I want to go back to that first court date because we really didn't talk about what happens on that first court date.
Okay.
When a petition for temporary relief is filed. It's a very important court date. Even if you're in front of the judge for only 2 minutes or 60 seconds for that matter, that doesn't mean that a lot of important things don't happen. Yeah,
Okay.
a lot of important things do happen on that date. Number one, if you're petitioning for child support, I always, or 90% of the time, subpoena the wage information prior to the court date.
You're
Why?
ready.
Why would I want to do that? Because under Section 505 of the IMDMA, I know what child support and how child support should be calculated. And if I have their wages, if I have their W-2s from 2012, then I can go into court and on that day specifically ask for temporary relief of child support. And in a case where you've got a mother who's 37 years old with 3 kids at home, she has an immediate need of child support if she is only by herself, bringing in $15,000 a year.
Right. Do you see temporary relief petitions filed for most divorce cases? Is that pretty common?
For my cases that I file,
Yes.
even in cases when I think that the parties are going to do a fantastic job of agreeing about things, if there's kids involved, I almost without exception file a petition for temporary relief.
Okay.
It is not to be overly aggressive. It is to make sure that the issue gets addressed. The worst thing that could happen to my client, again, going back to the example of a 37-year-old stay-at-home mom with 3 kids who has minimal income, is that she's not getting her child support. I want to get her child support right away. It can happen in a really nice way. It can happen by agreement of the parties. Actually, it often does happen by agreement of the parties. We don't even have to make arguments in front of the judge because we know what the statute says. We can do the math and figure out the child support on our own without the judge telling us what it should be.
So you've come to court and you have those figures ready. You're ready to tell the judge, this is how much my client will get in.
Well, I don't tell the judge.
Not tell the judge, but you by the statutes, you know how much.
I don't tell the judge. The judge can, within his or her discretion,
Raise or lower that.
raise or lower it. It's unlikely, but this is how it helps.
Okay,
You have subpoenaed the wage information.
right.
So you know that this guy grosses $5,000 a month.
Okay,
You know that his net income is $4,000 a month, and you know that there are 2 kids. So that's 28% of 4,000, 28% of his net income. You run those numbers by opposing counsel. They check your math, and then you can usually pretty easily have an agreement. There's always some nuances and exceptions and things like that, but I don't tell the judge.
so you don't tell the judge anything, but so
When we have an agreement, we approach the judge and we say, Judge, here's the math, here's the gross income, here's the net income. We have an agreement to have child support entered in at 28% of, say, that $4,000, and then the court has to approve it. So
this judge can raise or lower the limit. Basically, it goes on what he thinks is right and just.
the judge does have that discretion. However, in all practical purposes, the child support statute is followed without deviation.
Okay, so he just usually goes along with what you guys, both counsels, have agreed to. Typically.
Correct. That is correct, in as much as we are attempting to follow the law.
Right.
And judges will ask for numbers. What's the net income? How many kids? Because they're overseeing the process, and within, it doesn't take too long for them to do that, in that 60 seconds in front of the bench, but we do relay to the judge the facts of the case, and then by agreement, the order can be entered with the judge's approval.
All right.
So that's a very important thing that should happen on that first court date if wages are subpoenaed and you know that financial information, because you want to protect your client. Another important thing that happens on that first court date, if there are children involved, is that the judge will send the parties to mediation. I always tell my clients with kids, when they come into my office, I say, by local ordinance, the judges require mediation, and then I say to them, I require mediation. What do I mean by that? I think one of the best things that we have going in Winnebago County is the mediation process. Does it always work? No. Absolutely not. Is it always the appropriate process? No. In abuse situations, when there's violence in the home, when people are scared and being threatened, or children are scared and threatened, mediation is not appropriate. But in those other circumstances, it is very important that people begin the process of reconstructing their relationship and begin talking to each other about children that they're going to be talking about for the next 10, 15, 20, 25 years. Because divorce, while it ends a certain type of relationship, it does not end the relationship between the parties.
Right.
With kids.
Of course.
Kids. I mean, if you don't have kids, go your separate ways and whatever. It's done. But with kids, it doesn't end the relationship.
All right. So in our example case, you have filed for the relief, right?
For temporary
relief. You maybe have set up time for mediation. Or the judge ordered mediation. You've suggested mediation. All right. So what's happening now?
So we leave that first court date, hopefully with a child support order and a mediation order.
Okay.
The judge then will set a court date probably about 30 days out for a status on mediation. And the parties during that 30-day period are under court order. So again, it's not, they don't have a choice here. They're under court order to attempt to try to work things out during the mediation process. And I'll talk about that in a second. I wanted to say one other thing about maintenance in the context of temporary relief.
Okay.
Normally on that first court date, you're not going to get maintenance. The reason being is you need both parties to provide their financial affidavits, which lists not only their income, but also their expenses. And so usually what I try to do is by agreement of the parties, have an order entered that requires financial affidavits to be produced in 14 days. And then at the next court date, so on the same date for, say, the status on mediation, you can then argue about what maintenance should be because, you have Mrs. Smith, and maybe Mrs. Smith is making $100,000 a year, and she has $50,000 in expenses, and Mr. Smith is making $50,000 a year, and he has $50,000 in expenses. So Mr. Smith's net is $0, Mrs. Smith's net is $50,000, and then you can make logical arguments about maintenance. But maintenance usually does not get entered on that day. Obviously, there's, I'm sure, plenty of exceptions, but it just takes a little more time to make
later on in the process.
Right.
Okay.
So, sorry, go ahead.
All right. So we filed these petitions. I got the temporary relief. We're in mediation. The judge is checked up. He sets in a court date for 30 days to kind of see the status of the mediation. So are we assuming everything going smoothly at this point, right? Now, how often does it go smoothly in the first 30 days when they have to have mediation?
Sometimes it goes like clockwork. I was in court the other day, and I jokingly said to the judge, Judge, both parties are just too nice. Despite the best efforts of me and opposing counsel, we have not gotten them to disagree about anything. And obviously I'm joking. We were both very happy that they agreed through things by going to mediation one time. But often that's not the case.
So mediation. How often are the parties going to mediation? Is it once a week, once a month? How many times will you go see one of these mediators?
By local ordinance, mediation is required up to 3 times.
Okay.
The judge can cut it off before then, but by local ordinance, the parties have to try at least 3 times to work things out.
Right.
And this is what I tell people about mediation, too. I say, listen, mediation might not solve all of the things you guys disagree about, but if it solves 80% of the things that you guys disagree about, think about all the money you're going to save. Because the attorneys will not have to argue about that 80%. They're just going to have to argue about the 20% or 10%.
Right.
And so all that emotional energy that you would have been put into talking to your attorney, and then your attorney talks to the other attorney, and then all this back and forth is done away with because in the mediation process, you are able, with your spouse, to kind of, or your soon-to-be ex-spouse, to kind of take control of the situation, come to your own decisions about things, and work out 80% of the potential, disagreements between the 2 parties in the case.
Right.
So even if it's only partially successful, I still consider it successful because it narrows the issues.
Right. So I know you talked about mediators in previous episode here, but could you now, just as a refresher for those that might not tune into that, does a mediator are the opposing counsels at this mediation, or does a mediator kind of send a report back to the opposing counsels?
Very good question. Absolutely not.
Okay.
Attorneys are not.
So you're nowhere near it.
And it's a good thing, because I'd probably cause problems. I'd be sitting there the whole time and I'd say, "What about this? What about this? What about this? What about this?"
So the attorneys would be the ones bickering, not the divorcees, I guess.
Absolutely. I know I would be. I tell my clients, listen, it's good that you don't have me there. When you're done with mediation, let me see what you guys agreed on.
Right.
And I'll go through each of the paragraphs and I'll say, okay, paragraph 1's good, paragraph 2 good, paragraph 3 good. No, paragraph 4 is not good. This is why it's not good. You might not see your kid for 6 months.
Right. So the mediators are kind of filling out this standard form, maybe, that they plug in the information from that they talk about. So when you go to a mediator, do you have a set talk? They have a set talking points. This is what we're going to talk about.
You know what? I have no idea.
It's free. Okay. So yeah, you never know. So it could be free flowing.
I would imagine that it would depend on the mediator. I'm sure that different mediators have a different process.
Right. But the end result for almost every mediator then would be you get each attorney representing the clients would get some sort of report back.
Each attorney representing the clients would get a report faxed. I usually get faxed.
Okay. And then you guys will look at that.
And then I generally review that with my client to make sure that they haven't agreed to anything or potentially agreed to anything that is incredibly detrimental to their case.
Right.
Like, for instance, if someone came to me initially and said, I want custody, and then they came back and they somehow, without knowledge or without understanding, put an agreement that they didn't want custody, I'd say, hey, what's going on here? And if they say to me, hey, no, I've changed my mind, I really don't want custody, I'm fine. But if they say to me, oh, I didn't realize what that meant, I'm like, okay, well, we need to have a conversation about this.
Now, you brought up, so the mediator, they're not supposed to be on anyone's side, right?
And they're not on anyone's side.
Right. Now,
and that's one of the benefits of a mediator.
Right.
Generally, the mediators know the law. They know there's several things that they know. They know the law. They know our courtrooms. Our mediators are local, so they know how our local judges think and how they rule and how they apply the law, and that's very important.
Well, you mentioned they know the judges, which brings up a question. Would you typically have the same judge throughout the entire divorce?
Generally, yes. I mean, there's some ways that you can file to sub a judge, but it has to usually happen very, very early in a proceeding.
So you're working with the same judge the whole time?
That is correct. Okay.
So you've got this report back from the mediator. You've reviewed it with your client. The opposing counsel's reviewed it with your client. What happens next? Do you discuss it at the next court date then?
One more things I want to talk about.
Mediation,
and that is the mediation process only allows the parties to talk about custody and visitation issues, not financial issues.
Oh, so we're not talking about money at all?
Not talking about money at all.
Well, okay.
And there can be exceptions to that by agreement of the parties, but that is not permitted to be talked about in mediation. You're required by our court system to address custody and visitation first, and then the financial issues are addressed after that. And mediation in our county only deals with those two things.
So if you have no kids, you don't go to a mediator in Illinois.
That is correct.
Okay.
Well, you said in Illinois. I'm talking specifically about Winnebago County.
Winnebago County. Okay.
I think there's been felt a need in our general area to have financial mediation.
Okay.
I think as attorneys we get a little nervous sometimes about our clients entering into financial mediation. One of the reasons being is someone might sign away significant financial interest that they have, and they might not even know that they have that. Like for instance, let's say mom has worked at Chrysler for 35 years,
right?
And dad was not. Dad was, he worked but didn't have any kind of pension. Well, generally speaking, he is entitled to 50%, his marital share, of those 35 years of retirement at Chrysler. And he might not know that because, he just doesn't know the law.
Right.
So, and again, that's generally how it works. It's not always how it works, but it's generally how it works. So we get a little nervous sometimes about financial mediation because there can be some pretty significant financial consequences. In the collaborative process, there's financial advisors, financial coaches, but not in the general litigation process for a divorce. There's not financial mediation.
So the financial part of the divorce is primarily handled by the opposing counsels.
That's
and
correct.
Okay.
That's correct.
All right. So after mediation, we're going to court again, right? So you reviewed the mediator's report. You reviewed it with your client.
That is correct.
And then now at the next court date, we'd probably want to back up from there because say there's some things that you don't agree to in the mediator's report, and you said, hey, you don't want to do this. You're giving up visitation for 6 months of the year, right?
We sent them back to mediation.
We sent them back to mediation. So this could happen a few times back and forth. So after mediation, you've agreed everything, the visitation, all that. That's hammered out. Mediation's done. Where do we go from there?
So if they've gone back a couple times and they've hammered out everything,
right.
Well, let's say they've hammered out everything but 10%.
Okay.
Maybe mom and dad disagree about where the kids should be on Thursday nights. Okay, they agree about everything else. They agree about custody. They agree about all the other nights, but it's Thursday night. Dad's saying kids should be with me. Mom is saying absolutely not. They should be with me. Then that particular issue, we will maybe set up for some kind of hearing date for the judge to make a decision about that. It might not even be something where you need a guardian ad litem. It might just be like, Judge, here are the facts. Opposing counsel is going to make an argument. I'm going to make an argument. We need you to make a decision because the parties are in flux about this. But if they've gone through the mediation process and they've come to agreement about all the custody and visitation issues on a temporary basis, then we go to the next step.
Okay, and what is that?
The next step is getting them, is helping your client dealing with the financial issues. And generally how the process works is after we've gotten everyone's financial information, like where's your bank accounts, what debts do you have,
right.
Is your home underwater, or is there equity in the home? After we have all that information, we put together a marital settlement agreement which deals with finances and how debts should be divided up, how bank accounts should be divided up, all that kind of stuff. And we put together, or I put together a marital settlement agreement. I send it over to opposing counsel for them to review, and then I see what their response is, and we figure out whether or not we have an agreement.
So say you're in agreement. How often does it happen on the first try?
I've seen it happen sometimes on the first or second. I mean, I've had cases where parties won't agree about anything. I've had cases where they agree pretty much about everything. I mean, I had this one case, one in particular, parties did a fantastic job, and I was very careful. I didn't want to rock the boat in the sense that I didn't want to disturb the relationship, and so I was very careful with my client about, hey, is it okay? Here's what your legal rights are. Do you want to make an issue of it, or do you not want to make an issue of it? If they tell me they don't want to make an issue of it, then I don't make an issue of it. But it's my job to inform them of these are your rights. This is your rights in relationship to your financial interest. So that's pretty much how it works with marital settlement agreements.
Okay, so marital settlement agreement you've given it to the opposing counsel. They said, hey, it's fine. It looks good. We agree.
Then I am ecstatic because now I can get my client divorced, and my client is ecstatic.
So we're in the home stretch right now.
We are not just yes, we are definitely in the home stretch.
All right, so we're getting close.
So we've got, and I'll take a step back to the marital settlement agreement.
Okay.
Pardon me, not the marital settlement agreement, the mediation agreement. So you have the mediation agreement, and usually there's some kind of co-parenting or joint parenting agreement that incorporates that mediation agreement.
Right.
And that deals with other parenting issues such as, hey, information exchanges, all the teachers got to know who the parents are, and all the parents have got to be informed of doctor times and parent-teacher conferences, all those kind of things. But you've resolved that. You've resolved all the parenting issues, and you've got your parenting agreement. You've got your marital settlement agreement. And then what we do is we ask the judge to set the case for prove-up.
Okay, well, what's a prove-up?
Prove-up is simply a legal fancy word that means the day of the divorce.
So that's it.
That's it.
So that's the final day. Everything's over with after the prove-up.
On the day of the prove-up, you walk out divorced.
Okay.
And basically, prove-ups are times in court, a court date when both of the parties have come to agreements about everything, financial as well as child-related non-financial stuff. And that means there doesn't have to be a hearing on anything. There doesn't have to be, is Mrs. Jones right or Mr. Jones right? You know, who should win on this issue or that issue? Because why? All the parties have agreed to everything. However, you still have to get the parties divorced, and there's certain things that the parties have to testify to during the prove-up in order to get that divorce.
Okay. And what are those things?
Some of those things would be, you know, if you're getting divorced on the basis of irreconcilable differences, the parties have to testify, or one of the parties has to testify and the other one has to say yes in agreement that there are irreconcilable differences, and that these irreconcilable differences make it impracticable for the family to remain together, and it's in the best interest of the family that there should be a divorce, and that they have been separated for the statutory period, which is 2 years in Illinois.
So you have to have been separated for 2 years before you can get a divorce in Illinois?
Kind of. You can waive that 2-year period, and if you've been separated for 6 months and you can testify to that honestly, then that's grounds for a divorce as well. But as you can see,
so it's a strict requirement almost. Then you can't just say you had a bad fight one day, you haven't been living together for a week, I'm filing for divorce.
Well, you can file.
Right.
But there's a difference between filing and getting the divorce.
So you would have to wait then.
You would have to wait. If you cannot honestly testify that both of you have lived separate and apart in some sense for a 6-month period of time, and you've signed the waiver period, then you don't fall within the statutory requirements to get a divorce on the basis of irreconcilable differences. Now, there's other grounds for divorce.
And what are those?
You know, abandonment, mental cruelty, adultery. Those are still other grounds that people can get divorces in Illinois. Although, as you can see, they're more controversial. I mean, if you use mental cruelty, then someone is going to be found by the court to have been mentally cruel to their spouse.
And that's going to be on their record then?
I don't know what you mean by record. That sounds like criminal record.
Maybe like an employer does a background check on somebody, and then they say, oh, they went through divorce and they were mentally cruel.
I think that's pretty unlikely.
That's an unlikely situation.
I think it's unlikely. I think, though, the emotional impact of hearing your spouse say, hey, he or she was mentally cruel to me, can sometimes create waves in their post-divorce relationship, meaning they still have kids, they would prefer not to have said bad things about each other in court,
right?
Just because it makes it makes it easier for them to get along. That's the way I look at it. At least.
Okay, so you try not to use that mental cruelty.
Yeah, I mean, I have. It's
if it's needed.
If it's needed, if the other party is refusing to sign for irreconcilable differences for 6 months and waive a statutory period, then I attempt to use other grounds to get my client divorced because they really want to get divorced. But generally speaking, I try to avoid that simply because I don't want to create waves when there doesn't need to be. But sometimes there needs to be. That's just the way it is.
Right.
But on the day of the prove-up, that's one of the things that people have to testify to. And in addition, the parties testify, hey, this is the marital settlement agreement. This is the parenting agreement. I signed it, and the other party says, "Hey, I signed it. I agree with it." And those get incorporated into the judgment for dissolution that is entered that day on the day of prove-up.
Right.
When you get divorced.
Okay. So basically, that's it.
Basically, that's it.
We're done. The divorce is final. the parties are separate.
Your divorce prove-ups usually happen here in Winnebago in the morning. Out in Boone County, they're usually in the afternoon. So, get divorced about 9 in the morning and go to the Pancake House and
you're free.
and you're free.
All right. So that's it. That's then the whole divorce process from start to finish.
In a nutshell, with many, 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 many complexities in between. But if the parties are really trying to work things out, we try to make it as straightforward as possible.
I mean, it can be a relatively painless process if both sides are willing to work towards that sooner dissolution of marriage. Then.
Well, I don't know if I'd call it a relatively painless process. There's a lot of obviously complexities involved in emotions and things that are still obviously very, very painful, even if the parties have done a good job at trying to be agreeable with each other.
Right.
I've seen. I was talking to one attorney one day, and they were talking about a case they had some years ago where, both parties were crying on the day of their divorce. That's just being a human being. They probably did a good job at being reasonable and getting things done, but obviously, that's something that a good divorce process that is relatively agreeable can't help people with.
Right. The psychological trauma of it.
Right. But, absolutely making and streamlining the divorce process as quickly as possible that helps people move on with their lives is 90% of the time in the best interest of your client, and that's what I seek to do.
Awesome. All right, well, thank you, Brad, for walking us through the divorce process tonight.
Absolutely.
Awesome. Thanks.
You just heard a phenomenal episode of Divorce Talk Radio. Listen to Divorce Talk Radio live on RockfordCollegeRadio.com Tuesday evenings at 8 p.m. To hear more of Divorce Talk Radio shows, please visit RockfordCollegeRadio.com. To learn more information about attorney Brad Tengler, please visit TenglerLaw.com.